Hello, I'm Tim Broderick, co-author of the book, A Victim's Guide to Sexual Harassment in California. Welcome to this audio about the different types of sexual harassment-related claims that I deal with every day in my law practice for victims of sexual harassment. Courts have recognized two main theories of actionable sexual harassment based on the California Fair Employment and Housing Act. The first is quid pro quo harassment, which means this for that in Latin. Quid pro quo sexual harassment is when an employer or supervisor makes submission to unwelcome sexual advances a condition for either favorable employment terms or to avoid adverse employment actions. The second main theory of sexual harassment is hostile work environment. In order to be actionable in court, sexual harassment of the hostile work environment type must be sufficiently severe or sufficiently pervasive. Generally speaking, the courts have defined severe sexual harassment of the hostile work environment type as a sexual assault or a sexual battery, meaning an offensive sexual touching or threat thereof. The legal interpretation of pervasive sexual harassment of the hostile work environment type is when the harassment alters the conditions of the victim's employment and creates an abusive working environment. In determining what constitutes pervasive harassment, courts have held that the harassment cannot be occasional, isolated, sporadic, or trivial. The plaintiff must show a concerted pattern of harassment of a repeated or generalized nature. Retaliation against employees who make sexual harassment claims is prohibited by the California Fair Employment and Housing Act. An employer cannot retaliate against an employee who makes a claim for sexual harassment or against an employee who supports another's claim for sexual harassment, such as a supportive witness for a victim of sexual harassment. Another subtype of sexual harassment includes spreading rumors about sexual behavior, which is akin to defamation as a method for sexual harassment. Yet another subtype of sexual harassment is when gender discrimination is manifested through yelling or other behaviors at work directed towards a particular gender, even if the yelling or abusive behavior does not have sexual content. Also, sexual harassment is not limited to the workplace. California Civil Code Section 51.9 prohibits sexual harassment in business, service, and professional relationships where the victim is unable to easily terminate the relationship. Other legal means accompany a complaint for sexual harassment are infliction of emotional distress, sexual assault, sexual battery, and in some cases, false imprisonment, invasion of privacy, and stalking. Sexual harassment and related claims are a complicated area of the law. Please do not hesitate to contact us for information. Thank you.